Okay. Good afternoon.
Good afternoon, Your Honor.
On the record, in the case of Giles versus Justice, D569413, and Justice versus Giles, T187632. Your appearance, please.
Your Honor, Mark Anderson, bar number 606, appearing for Attorney Kurt Smith, with the plaintiff who is present.
Thank you.
I've not seen the defendant.
Okay, all right. And you received the drug test report from the defendant?
I did, Your Honor.
Okay, very good. All right, you can be seated, sir.
Thank you, Mayor.
Counsel, you want to fill me in on mediation was not yet completed. I see that they have another appointment tomorrow.
That's correct. Mom did file a motion asking the court to waive his ex parte, and the court denied that. Mom was served on April 20th with the complaint. She's been served with the motion. She still hasn't filed any answer. She's not filed any opposition to the motion. She has not filed her own motion seeking custody. She did file the protective order back in April before we were here on May 8th. And the representations she made on May 8th, I think, are certainly contrary to the representations she made in the protective order. As the minutes for the May 8th hearing show, she basically recommended to the court a 1 week on, 1 week off, testified or represented that the parties had been sharing custody since they separated in August of 2017. Dad disputes that and would testify that he had custody of Dean for the substantial bulk of that time, that Mom basically left saying, you take care of your son, I'll take care of mine. So again, if she was really in need of protection, I would think she would be here asking the court to grant her a protection order. She's not here. The only real contact my client has had was they saw her yesterday, just happened to be in the car and another car pulled up, she was in it, and she flipped them off. She denied Dad any contact for Father's Day, posting on her Facebook a message, F you. When we were here last, the court referred the parties to mediation, and for drug testing, the parties went down, signed up for mediation. By the time they got over to ATI was closed. My client, and we've put it in supplemental exhibit, did get a card signed from the director there.
I saw that. I appreciate that. Thank you.
And he got Mr. Smith involved. They called that very night and made arrangements to get testing at the facility. I
have no problem with that.
Okay. So Dad has not seen his son since March 28th. When basically Mom concocted events to get him arrested. He did go to court on that. No charges have been filed to date.
Okay.
They continued the matter. They were still wanting to do testing. But he comes before the court as someone charged with 2 misdemeanors that not formally charged because they haven't filed a complaint. But he's obviously presumed innocent in the eyes of the law. This child needs to see his father. And Mom has finagled things so that that has not occurred. She acknowledged in the May 8th hearing that she not only entrusted Dean to Dad's care, but also her son Coda. She told the court that she would have James watch both children while she went to work. She claimed that they shared custody upon their separation. There's absolutely no reason why Dad should not be able to see his son. The sooner the better, because again, this boy deserves to have Dad in his life. Dad's advised the court that he would test positive for the prescription drugs that he tested for. He's provided, he's an open book in that regard. He's provided his prescriptions.
I saw that, yes.
And there's no issue there. The parties, I think, are going to return to mediation tomorrow. I think Mom has basically told Dad that, I'm not going to mediate an agreement. You've got positive drug tests and you got charged. She's of no mind to try to negotiate this. I think if the court would show her that Dad's entitled to contact, that might go a long way for her to be more realistic in the mediation. And again, we come before the court with a complaint that hasn't been answered, a motion that hasn't been opposed, in writing at least, and we'd ask the court to grant the relief requested in his motion, on a temporary basis at least.
I agree that I have to make findings of fact and conclusions of law for custody, but temporary orders can be entered. And because she is not here, for whatever reason, the protective order is not granted. Because it did require a hearing, Madam Clerk. It was not issued in the first place. It required a hearing, so I'm not granting it. And your drug tests were consistent with the prescriptions that you were given?
Yes, ma'am.
And I saw that. I saw your prescription history. I saw your drug tests. I don't believe that you were trying to avoid being tested.
No, ma'am.
And what custodial schedule are you requesting at this time on a temporary basis?
James,
As
you want to go to the...
I would like, as I stated when I first was here, Your Honor, that if I could go back to where Felicia could see Dean 2 days a week at her convenience. She's always chosen Monday or Tuesday or Wednesday and Thursday. That's just how it's been, and she has not. She lied in this courtroom telling me that we shared this type of custodial back and forth with Dean. She never even seen or came around or called or even cared if my son was alive or dead until Thanksgiving.
Tell me what you're asking.
I'm asking for 2 days a week for Felicia to be able to see Dean if she even chooses to, either on Monday or Tuesday or Wednesday or Thursday.
The problem with giving the flexibility is the two of you are not cooperating and communicating, and I'm not blaming you or her. I'm just saying that it won't work unless we have a solid time frame.
Your Honor, you did tell her at the last hearing to file her work schedule. She filed an FDF, and it indicates that she works Monday through Wednesday and Saturday, 11:30 a.m. to 5:30 p.m., so with Thursday and Friday.
But that would be perfect, Your Honor.
It would appear to be her days off.
All right, and she'll pick up at your residence?
Since everything that's taken place, Your Honor, I honestly would feel more comfortable if I could have the exchange done at the Henderson Police Department.
Okay.
I just, with her father being involved and so many things that have been fabricated and stuff, I don't feel safe anymore.
A very good idea. All right, so what time on Thursday?
About 3 o'clock.
3 p.m. And
And I'm thinking of Coda as well, because she picks up Coda from school at 3:30. So that way, every time she goes to pick up Coda, his brother's there, and Coda loves his brother. And I think of those things, but she doesn't.
all right, Thursday to when? I'm sorry, counsel.
Well, Thursday to Friday, because she's off on Thursday and Friday.
Yes, sir.
So Friday, what time?
In the evening time, suffice, maybe 4 o'clock, after she picks up Coda. I want to give Felicia time.
But they're not in school right now.
Okay, so this is just temporary. It's not
Yeah,
a
can we
permanent
do
thing.
it Thursday at 5 to Friday at 5?
Yes, ma'am, Your Honor.
Okay, and this is, Madam Clerk, this is just regarding the child Dean. I know he keeps mentioning another child that's not of this relationship. So it will just be for Dean Thursday, 5 p.m. to Friday at 5 p.m.?
Yes, ma'am.
And I'm sure we'll hear from her after she gets this order. It's a temporary order.
As far as him being able to effectuate the custody,
Need something in writing.
you need to submit an order, and
And you'll have to serve her with it. But he can certainly let her know at mediation if she shows up tomorrow.
we will get an order to the court forthwith.
Okay. And I'm going to give you a trial date. I know it's not your CMC, but there needs to be a trial date in this case.
November 13th at 9 a.m.
November 13th?
Yes.
For a half day?
I think we could do that in a half day. Child support, her FDF said 1,040 gross monthly income. We think 18% of that would be appropriate.
I'm not saying you're not entitled to child support, sir. I'm just going to defer that until she's here. I didn't get any paycheck stubs from her. I just got a stated income.
So basically all the issues, other issues in the motion are deferred until trial.
Yes.
Okay, so we'll be,
But
still
I'm
be
sure
able to raise it.
we'll be back before then, because I have no doubt she will now get involved in the litigation and be filing papers, so.
Okay.
And that's not the reason for the orders. The reason for the orders is that historically he has had the child. He's not being charged with any criminal acts out of Henderson, out of the actions that were alleged to have been committed. He's not abusing drugs. His drug tests came out consistent with his prescriptions, and I see no reason why the historical timeshare should not be restored on a temporary basis at least, until the two of you can either come to an agreement or we have a trial. And I would appreciate those findings in the order, counsel. Thank you so much.
We'll do.
Okay.
Yes, ma'am.
I think that covers it for today.
Thank you.
Thank you, Aaron.
All right, thank you, Your Honor. So.